So first of all, happy International Women's Day to everyone here. This is, we thought, a ripe opportunity to reflect on what that means to all of us in the various contexts we live and work in. And thank you so much for spending your day with us for this event. Thank you everybody for being here today. My name is Poonam Sandhu, and I have the privilege of co-moderating today's event titled Gender Justice and Lived Legal Pluralism, Advancing Equity Through Human Rights Instruments. Alongside with Kassandra and Neranjan, I'm the co-editor-in-chief and co-host of today's event, and which is being hosted by Inter Gentes, the McGill Journal of International Law and Legal Pluralism. To give you a little bit of background, Inter Gentes was formed with the ethos of rethinking the intersection of international law and legal pluralism and creating a space for meaningful dialogue. And we're hoping that we can do just that today. I'd also like to mention that we're delighted to also be co-hosting the event with the support of the Center for Human Rights and Legal Pluralism here at McGill. We have the co-director here today, Professor Nandini Ramanujan, and we'd really like to express our gratitude for their support, as well as to Sharon Webb, who's been an invaluable part of the organizing team on behalf of the center here. So thank you so much to all. Before we begin the discussion, we'd like to engage in a land acknowledgement. Since many of you may be speaking from multiple different regions in the world, we'd also encourage you to focus on the spaces you occupy and your relationship to it. McGill University is located on land which has served as a site of meeting and exchange among Indigenous people, including the Haudenosaunee and Anishinaabe nations. We honor, recognize, respect, and thank these nations as the traditional stewards of the lands and waters on which we virtually meet today. And with that, I'll pass it over to my co-moderator, Juliet, who will introduce today's discussion topic and speakers.
Hi, everybody. Thank you so much for being here. My name is Juliet Kurchi, and I will be co-moderating today's discussion alongside Poonam. So today's event was planned with a few goals in mind that we hope will stay with you throughout the panelist presentations and after the event itself. This being International Women's Day, we want to create a dialogue marrying conversations of legal pluralism and gender equity. In particular, our aim was to host a forum looking not just at what legal pluralism is and is not, but how it is lived and put into practice. In this case, how legal pluralism is used to advance gender justice through a wide variety of legal and governmental instruments, international, customary, and local in scope. Our second aim for the event was to present speakers whose work helped examine the particularly complex and current experiences of women in Afghanistan as a legally pluralistic state and other states like it. We'd like to discuss how legal pluralism can and has functioned to respond to issues women in Afghanistan face, and how the varying and coexisting legal systems and integrated tools within the state, including international human rights mechanisms such as Cedaw and local governance, may advance gender equity for Afghan women and those in similar conflicts. We have structured the event to begin with 2 presentations by our speakers, followed by a discussion period moderated by Poonam and myself regarding the work and research presented. If you have a question during or after the presentations, please feel free to enter them into the chat or raise your hand, and we will make sure to include them in the Q&A. With that, I will now introduce our distinguished speakers. So first, we have Dr. Geoffrey Swenson, who is a senior lecturer teaching on international relations at City, University of London. He is a chair member of the Council on Foreign Relations and an external affiliate with the Ostrom Workshop at the University of Indiana Bloomington. His research focuses on post-conflict reconstruction, democracy and the rule of law, legal pluralism, international institutions, international relations theory, and foreign aid. Dr. Swenson's previous work includes acting as an in-country program manager of the Asia Foundation in Timor-Leste in Nepal, as the founder and in-country director of Stanford Law's Timor-Leste Legal Education Project, and a global political party development specialist with the National Democratic Institute. Dr. Swenson's research has been published in leading journals, including International Security, World Development, International Studies Review, and the Columbia Human Rights Law Review. Next, Dr. Meghan Campbell is a reader in international human rights law at the University of Birmingham, with her research exploring how the international human rights system can best respond to gender inequality and poverty. Her monograph, Women, Poverty, Equality, published in 2018, explores how the concept of equality in Cedaw can be interpreted to address gender-based poverty. She has published research on gender equality, human rights, international legal systems, and public law, and produced written evidence to the Joint Committee on Human Rights and Women and Equalities Committee. Together, Dr. Swenson and Dr. Campbell will be presenting their work on women's rights and legal pluralism in post-conflict states, looking at the role of Cedaw as a potential instrument for advancing gender equity. Lastly, we have Palwasha Kakar, who is the Interim Director of Religion and Inclusive Societies at the U.S. Institute of Peace, where she joined after 4 years with the Asia Foundation as the Afghanistan Director for Women's Empowerment and Development. She has experience in the United Nations Development Program's Afghanistan Subnational Governance Program, the Gender Studies Institute at Kabul University, and has worked with the World Trade Group on gender, justice, and environmental issues. As an Afghan American, Ms. Kakar has taught and researched religion, gender, security, and local governance, taking her to Afghanistan, Pakistan, Bangladesh, Egypt, Israel, Palestine, Jordan, and Syria. She has published research regarding women's participation in local governance, Pakistani Afghan customary law, Afghan women's identity, and social spaces in Afghanistan. Ms. Kakar will be presenting on her research and work on customary law, women's roles in local governance and legal systems, and issues of gender, peace, and security in Afghanistan. With that, I thank you once again, and I will now turn to Dr. Swenson and Dr. Campbell to begin their presentation.
Thank you so much for the warm invitation, and it's so wonderful to be here with everybody this evening for us in the UK, and this morning or this afternoon for those of you in Canada. So I'll begin by introducing our paper, and myself and Jeff are going to jointly present the arguments in the paper, because the paper is truly a marriage of two research disciplines, where I come from the women's equality background and Jeff comes from a legal pluralist background. And our argument is looking at how to advance women's rights in legally pluralistic post-conflict states. And we focus both on Timor-Leste and Afghanistan. And advancing women's rights after conflict is, probably not surprising to the people on this Zoom call, immensely difficult. But, as many have recognized at the same time, it's an opportune moment to think about changing pre-conflict laws and norms that were discriminatory against women. And in our presentation today, and in the article that we wrote, we dive into this difficulty and focus on a largely overlooked aspect that's central to fostering gender equality in post-conflict states, an aspect that's obviously of interest, again, to people on the Zoom call, which is the role of legal pluralism. So after a conflict, the capacity of the state system can be quite limited, and the non-state system can handle a vast majority of human rights disputes. But the role of non-state justice in realizing women's rights is either ignored, or it can often be demonized as being sites of gender oppression. And we argue in the paper this might be too pessimistic of a view, or too dismissive of both the realities of non-state justice in women's lives and the potential of non-state justice, and what women might want to see is where they go to achieve justice. So non-state justice has a potential to be a strong partner in promoting women's rights, but at the same time, it can also, it can undermine rights and the whole reconstruction process. Both can be said of the state, though, at the same time. And the background operating principle of our article, our argument, is that women in post-conflict states should be able to uphold their human rights, uphold their gender equality, no matter what form they seek justice in. And we thought, with that operating principle in mind, we then turned to think about, well, what does the international human rights system, how does it respond to this on-the-ground reality about the conflicts around state justice and non-state justice and women's rights? And we thought about the UN Convention on the Elimination of All Forms of Discrimination Against Women, or Cedaw. And it's easy to dismiss Cedaw in this context. It's based in Geneva, it's miles away from on-the-ground realities. It's easy to dismiss it as this kind of ivory tower, navel-gazing body that just sort of speaks vaguely about women's equality. And so we have to think about, what does it matter what Cedaw and the Cedaw committees say about women's rights in legally pluralistic post-conflict societies. And although it's easy to dismiss Cedaw, we want to argue that it's actually a really important cultural focal point, and it can provide meaningful guidance to a plethora of actors: the state, civil society, women's organizations, women themselves, to ensure that these really powerful bodies, when working to protect women's rights, don't make missteps or upset balances of power between state and non-state justice. And the effectiveness, though, of Cedaw and the Cedaw committee in providing that cultural focal point depends on their ability to provide recommendations that are tailored, that are specific, that speak to the unique reality of legal pluralistic post-conflict contexts. So our presentation today is going to provide a theoretical framework and strategies to think about women's rights in different types of legal pluralism. and then turn back to the Cedaw committee's work and think about how with that kind of theoretical richness in mind, look at how they've applied it to Afghanistan and Timor-Leste. And then think furthermore about how Cedaw and other actors can help foster or understand or harness the potential of legal pluralism to ensure women's equality. And we'll begin by just sort of, maybe not everyone has spent the past decade of their life talking about Cedaw. So I thought maybe we'd spend the first little bit talking about Cedaw, then I'll turn over to Jeff, who will provide a theoretical background on legal pluralism. Then I'll speak briefly about what Cedaw is doing in relation to legal pluralism, and then we'll kind of both conclude with where we think legal pluralism in the two countries and within Cedaw might be going in the next few years. So turning first to Cedaw, it's the treaty on women's equality. It was designed and drafted in the 1960s and 70s and came into the force in the 1980s. And it's really a response to the failure of the two mainstream human rights treaties, which is the International Covenant on Civil and Political Rights and the International Covenant on Economic and Social Rights, to take women's rights seriously. If you look at their work from the 60s and 70s, it's always like one little paragraph dealing with women's equality. So they're pretty ghettoized, pretty marginalized. And women within the UN system were quite vocal in saying, we think we need to have a treaty that focuses just on women's equality. And so Cedaw is unique in that it's asymmetrical. It's focused on women. It's not, doesn't really touch on men. There's some interesting work being done now thinking about where Cedaw might need to, how Cedaw could deal with trans women and non-binary women, but that's a whole other topic for another presentation. What is also interesting about Cedaw is that it combines civil and political rights and economic and social rights. So it's a whole comprehensive system. But when you read the text, it mentions very little about post-conflict situations or about legal pluralism. So on the surface, it doesn't really seem to provide much tools to speak to these realities. But luckily, Cedaw is an evolutionary text, which means that we're supposed to read it in a dynamic way. We're supposed to understand how obstacles to women's equality are emerging, are new, and think very carefully about what are the actual de facto obstacles and how can we respond using law to those obstacles. So if we read the text, we can see that there are tools there that will give us a hook to use the treaty to talk about women's equality in non-state justice. So Article 2 requires states to abolish and amend discriminatory customs. And Article 15 requires equality before the law. So these are kind of the two textual hooks that bring us into the realm of thinking about how to use Cedaw. And just how the committee Cedaw actually works. Obviously, it's an international treaty, so it's not binding in the way, or not, it is binding in the international plane, but it doesn't give, like, if the Cedaw committee speaks, that doesn't mean the law is going to change automatically in the domestic state. What the committee's task to do is to monitor states' implementation. And the main way it does that is through periodic reporting. For those who are not steeped in the UN treaty process, basically every 4 years, the state submits a report saying these are the things we've done to implement the treaty. Unsurprisingly, states are not always good at giving a critical assessment of what the work they have or haven't done. So civil society groups provide shadow reports that provide that more critical take about where things are not working so well. And then the committee releases basically a report card saying, these are the areas you need to think about and work on. It also provides general recommendations where it kind of takes a step back and synthesizes all of its knowledge from that reporting process and provides kind of a definitive statement on women's equality in various aspects of life, including in conflict situations, which they released back in 2013 or 14, I think. And those can be quite influential. They have been the backbone for some legislation in India. And the other two ways is through individual communications, which are much more like judgments where people can write to the committee, and through this inquiry process. And these are also quite influential, where they can have, as a Cedaw scholar, you always have to make sure you push how important Cedaw is. It's not irrelevant. The optional protocol inquiry procedure was formed the backbone for liberalizing abortion laws in Northern Ireland. It's very influential and became codified legislation. So on the surface, Cedaw it's committed to women's equality in all areas of life, all fields of life. It provides rich tools to think about that. It gives us sort of textual hooks and has a sort of complex monitoring process that has different platforms in which it can speak to about women's equality. So with that kind of foundation in place, I'll turn to Jeff, who will guide us through the theories of legal pluralism.
Thanks, Megan, and thanks everybody again for the invitation to speak today. It's a real honor, and I'm really looking forward to the discussion. I also appreciate the fact that we were able to get 32 people here without the inducement of free pizza or any of the other things that are sort of normally offered, at least when I was in law school, on a regular basis. So I know you're actually here because you're interested, which is very flattering. So thanks again, everyone. And I'm just going to talk a little bit about how we conceptualize legal pluralism and why it's relevant for our discussion about promoting women's rights and trying to advance gender equality through Cedaw and other mechanisms. And ultimately, at its core, legal pluralism is about constraints on the state. At its core idea, you sort of assume the state has a monopoly on the provision of justice. And I think especially from the legal side, there's this sort of assumption that law comes from the state. Of course, most of you here would realize what a problematic statement that is, but I do think oftentimes people just assume that law is state law. But of course, the lived reality of people is radically different, and it's estimated that in the developing world, 80 to 90% of all disputes are actually handled through non-state justice mechanisms. And so this means that there's a fundamental tension between how law is often conceptualized and how law is often lived. And so what we're trying to do is sort of think about this in a more theoretically rich way and think about different types of legally pluralist relationships between state and non-state justice and how they might be constructive or less constructive for a wide range of issues, but particularly efforts to advance women's empowerment in post-conflict settings. And so we identified sort of 4 big picture relationships, which are going to be more or less constructive for promoting women's rights. And the first of this is this idea of combative legal pluralism. And this is, sorry, my office is haunted, so periodically the lights turn themselves off. So the first of these is combative legal pluralism, wherein the state and non-state justice actors actively oppose each other and attempt to destroy each other. And this may sound, far-fetched, but it actually is extremely common. And indeed, this was the dominant mode in Afghanistan up until the Taliban victory last year. The Taliban justice system was one of the key aspects of the Taliban insurgency. And so you sort of have these different systems, these different justice systems on profoundly different normative foundations, and they're sort of going to clash. Now, this doesn't mean necessarily that nothing can be done to advance women's rights in these circumstances, but it's a different type of sets of options. You can do this by trying to encourage the state justice system to be better for women. You can do this by trying to mitigate some of the biggest abuses of the non-state system, but you have a lot of tension here because, again, structurally the systems are opposed. The second system is what we call competitive legal pluralism, wherein the state's overarching sovereignty isn't challenged, i.e., people aren't trying to displace the state itself. However, the non-state justice system retains lots of autonomy and has the ability to sort of act with its own goals, motivations, normative beliefs, etc. And oftentimes, this leads to a lot of tensions in the areas of women's rights. And this is also a particularly common type of relationship in post-conflict settings for exactly the reasons that Megan talked about. The state institutions have been weakened, there's a lot of conflict, and the state itself may have some pretty serious legitimacy challenges. And next we argue that there's different, and so you can think of this as a spectrum, right? On one side, you have combative legal pluralism, and we're sort of getting to increasingly sort of constructive relationships that may have greater sort of traditional options for engagement of state law. So competitive legal pluralism, there's autonomy. They're not trying to get rid of the state, become the state, but there is still a lot of tensions. And the third is this idea of cooperative legal pluralism, wherein the state and the non-state justice sector broadly work together and have similar goals, yet at the same time, areas of tension still exist. And so one of the areas that we highlighted this as being the case was post-conflict Timor-Leste. So in Timor-Leste, you had a new state. It was broadly seen as legitimate as a result of the sort of prolonged independent struggle against Indonesia. However, there were still some tensions between the non-state justice system, which had a very, had a much more sort of, I don't know what the word is, but a sort of traditional view of the sort of role of women in the society, while we had the more modern justice system, modern quotation marks, which was sort of more committed to the ideas of things like Cedaw. And so you could sort of see how over time, the state was able to take a series of actions, sort of help produce more positive outcomes because the state was broadly aligned with the non-state justice sector. So, and the final relationship, which isn't as common in post-conflict states, but is very common in places like the United States or Canada or other places, is this idea of complementary legal pluralism. So legal pluralism exists, however, it's firmly under the control of the state. In other words, think of your standard arbitration agreement or all these sorts of things where you have the ability to opt out of state law, but you can still, within certain parameters, rely on the state to enforce your arrangements, right? So legal pluralism exists everywhere, but the type and the dynamics of legal pluralism are going to vary dramatically. So I'll say a little bit about Afghanistan and Timor-Leste at the end, but one of the key things I want to flag about why Cedaw we think is a particularly useful mechanism for addressing a broad range of relationships is that Cedaw is able to actually accommodate different types of dialogues for different types of actors in different types of situations. And unlike some other mechanisms, which tend to assume certain types of parameters, Cedaw actually has the ability to speak to very different types of circumstances and ideally respond to things pragmatically, think about how best to improve the situation for women based on the actual conditions on the ground, rather than idealized or sort of, best case scenarios. So that's my sort of big picture discussion about legal pluralism and thinking about legal pluralism, and then I'll come back around to the specifics at the end. But now I'll pass it back over to you, Megan.
I think your point is spot on, unsurprisingly, since we wrote this paper together and talked about this before, that Cedaw, in theory, has some really interesting tools about how it could be speaking to on-the-ground realities. The periodic reporting process allows for the state to bring forward its sort of narrative about what's happened for the past 4 years, but it has that shadow reporting where literally anyone, students at a university, an individual can send in a shadow report to say, actually, this is what's happening on the ground. So in theory, it has a richness. And because it's an international treaty and it has this global perspective, there's, I think, 191 signatories. It has to be speaking to the realities. 191 states it's reviewing radically different positions on women's equality in radically different contexts. So it has to be very nuanced and tailored. And while it has that potential, we argue and firmly believe in it. When it comes to the actual application of legal pluralism and women's equality, I think it's fair to say our takeaway thesis is that Cedaw and the Cedaw Committee reflect a deep uncertainty about legal pluralism and women's rights. And it can veer between skepticism, it can veer between high degrees of pessimism, and I would say some kind of acknowledgement of on-the-ground reality. And because of this uncertainty, its recommendations are often erratic, and its recommendations are kind of generic and rarely speak to the on-the-ground relationship between women, non-state justice, women in the state justice, and between the non-state justice sector and the state justice sector. So often its recommendations just seem like they're coming out of left field. They're just not aware of these complex relationships. And so they're not particularly, when they're not speaking to the reality, they get easy to dismiss and ignore. And we think that's a problem because then you're dismissing essentially dismissing the whole entire project of trying to achieve women's equality. So the first thing I'll look at is just the general recommendations, which I said are these longer statements that bring together all the committee's learning, and they kind of act as, they're probably the most authoritative. They're the things that get cited the most, the things that are probably read the most by people who study and think about Cedaw. And in these general recommendations, there are two that are highly relevant for today. One is on post-conflict and one is on access to justice. And we can see this erraticness within these general recommendations, because at times the committee calls legal pluralism discriminatory in and of itself. So the fact that there is legal pluralism is itself a source of discrimination against women. And we think this is very problematic because it's just letting go of something that could be quite rich and useful for women's lives and just kind of washing it or kind of blackballing or putting into the void. But it does reflect a certain strand of feminism that wants to do away with non-state justice, that sees these these sites, usually because of their connection to traditional norms about gender, or their prejudice or stereotypes against women's equality, think that non-state justice is just too problematic to be saved, and its existence is discrimination. And of course, we think it's probably too pessimistic because, as I said earlier, it has this promise and potential. But there's also another important element that often non-state justice, not always, but often, can be important for women to recognize other aspects of their identity around their own cultural identity. Often these are based on traditional norms and cultures, and the goal isn't necessarily for these women are not always wanting to say, I want to go to the state, but they want to internally reform the system because it is how they identify or see themselves. So recognizing the cultural rights that might adhere to non-state justice, or the agency of women to desire to have non-state justice reflect their own understanding of their culture, means we can't just dismiss non-state justice as inherently discriminatory. And that kind of idea of legal pluralism is inherently discriminatory, one author writing in the context of sub-Saharan Africa, as it just kind of continues this polarizing of culture and rights. That culture is one thing and rights are another, and it's not quite seen how women's equality, culture, and rights can all be kind of positively intertwined. There are some, as I said, it is erratic. So there's these statements where they're very dismissive of legal pluralism, and other times there's more of acknowledgement of its reality, that it does exist, particularly in post-conflict societies like Afghanistan, and that it might be the primary source, particularly taking that intersectional perspective for rural women or women in remote communities, that this might be the only option that they have to achieve any sorts of accountability. And they offer a series of recommendations. For example, that not all legal matters should go to non-state justice. So they try to sort of funnel funneling approach where some matters can be reserved for non-state justice and some matters have to be reserved for state justice. The key ones that they say should go to state justice is always gender-based violence, which takes up a lot of the Cedaw committee's work, but anything about non-gender-based violence should be seen as running through the state system and not the non-state, because there is this, the Cedaw committee perceives that non-state justice will result in too much mediation or acceptance or dismissal of gender-based violence against women. They also recommend a right to appeal. So if you have a decision in the non-state justice sector, that there's an automatic right to appeal to the state justice system. So the non-state justice system will always then sit below the state justice. They encourage dialoguing with traditional leaders, with customary leaders, or with other non-state justice actors to internally reform. And when they recommend that, they also recommend including women's voice and agency and participation in that reforming process. And lastly, they kind of talk about legal aid in rural courts, about ensuring that particularly rural women in remote communities can access the state justice system or non-state justice system by having access to legal aid. But what's missing from the general recommendations is any guidance on how to use these different strategies in any meaningful way, or how to reflect on what type of non-state justice, state justice relationship there is, and how different strategies or different ideas might be more effective or less effective depending on the context you're working in. So it kind of gives all of the ingredients, but doesn't kind of tell you how to use those ingredients in a way that might be helpful. So turning to our two case studies, again, we can kind of see this lack of attention to context about non-state justice kind of come to the fore in Timor-Leste. As Jeff mentioned, Timor-Leste had a more productive relationship between the state and non-state justice system. But the committee's recommendations are all kind of focused towards improving the state system. Just, strengthen the state system, make it more responsive to women's equality, make sure it's dealing with gender-based violence in a way that's efficient, make sure it's accessible to women through legal aid, etc. Well, obviously that's important, and we would not be arguing that state justice system should not be a site for women's equality. It's disappointing when there is a productive relationship between state and non-state justice. The committee doesn't seek to harness or emphasize or bring to the fore that relationship, or think about how that relationship could be strengthened to ensure women's equality both in the state system and the non-state system. So there could be recommendations, for example, about empowering women to be agents of change and to work towards reforming the non-state justice system, or training for non-state leaders on the value and importance of women's equality. But basically for Timor-Leste, it's kind of missing speaking to a certain reality. We can see a similar pattern in Afghanistan. So the Cedaw committees all reviewed Afghanistan once when we wrote the paper back in 2015. And today in prep, I was looking, they reviewed it also in 2020. But there hasn't been obviously any reviewing of Afghanistan since the Taliban came back into power. So the recommendations are obviously a bit dated, but they do kind of are emblematic of the committee's uncertainty around how to understand the realities of non-state justice. So the problem when it comes to Afghanistan and the Cedaw committees, it doesn't draw any distinction between the Taliban, who's obviously more, especially at the time, more combative relationship and was actively seeking to overthrow the state, and more traditional leaders who would be in a more competitive relationship with the state, trying to kind of carve out a legitimacy sphere. So they kind of lump them up as the same and don't recognize that there are, deep differences between the Taliban and traditional non-state justice systems in Afghanistan. And then because of this, their recommendations seem kind of odd or misplaced or like confusing, to say the least. They recommend that, the state justice system should dialogue with the non-state justice system to work at achieving women's rights. Well, the Taliban is not going to dialogue with the state justice system because it is actively seeking to overthrow it. So you need, the committee could bring a bit more nuance and a bit more subtlety to its recommendations so they are, again, speaking to that reality. It does recommend, unlike in the general recommendations where sometimes it's slightly dismissive of legal pluralism, it does try to recommend a working between traditional law and state justice, which could be helpful in carving out space for non-state justice, but demanding that it respect women's rights. At other times, it seeks to, well, actually, maybe I'll just turn to in 2020. So 2020 was the last time it reviewed it. And here we can see a shift, maybe a more skepticism around non-state justice, where before was kind of advocating for some type of dialogue. In 2020, it's back to that skepticism and uncertainty, or requiring all gender-based violence matters to go to the state system rather than the non-state system, requiring a right of appeal to the state system for all matters that have been decided in the non-state, and advocating the NGOs be given support and training to help women navigate parallel legal systems. So basically to help educate women about the realities of legal pluralism and what their rights might be in competing competitive legal systems. And what's perhaps interesting, and where I'll wrap up before turning to Jeff with his conclusions, is that it talks about non-state justice in relation to marriage and about marriage certificates, marriage registration, which is interesting because it's quite new for the community, where mostly its relationship with non-state justice has been focused on violence and skepticism around the inability of these systems to deal with violence. But it's slowly moving towards marriage and how family law and non-state justice can interact and should interact. As this is kind of a new frontier, as it brings up many difficult issues around recognition of marriages, the division of property, recognition of children, child support, and speaks to not only post-conflict societies, but also to other communities that have customary marriage laws. I've been doing some research recently in South Africa, looking at the various customary marriage laws there and how should they be internally reformed, should they be abolished. So this is something the Cedaw committee has a kind of, again, a very ambiguous relationship with, and it doesn't provide always the degree of clarity that might be required, but it's kind of signaling that it's moving into thinking about non-state justice beyond just violence and looking at it in relation to other areas of life. I think that's something the Cedaw committee is going to have to look at more in the future. But I think we might be getting close to the end of our time, so I don't want to take away Jeff's conclusions, so I'll turn it over to him now.
Thanks. I'll just add a few points, and I will also add a quick disclaimer that I was asked by the conveners to think a little bit about sort of the current situation in Afghanistan and sort of what are some of the big issues there in sort of wake of the Taliban takeover. So this is my sort of brief thoughts, not fully fleshed out and also not pre-approved by Meghan. So if I say something terrible, blame only me. But basically, I think we need to think about how to work with what's there and what's sort of constructively possible in order to make the best of what is admittedly a very challenging situation. So I think we have to really resist the temptation to idealize state law and assume that state law is always better. And we also have to work with the reality that however you feel, the Taliban actually did win the conflict there. And so I think you're faced with a real stark choice, which is trying to think about, are we going to try and maintain some sort of ideological purity, or are we going to try and think about what are the possible actions to try and actually improve the lived experience of people's lives in Afghanistan? And I think, at least for me, I think that we need to think about what are the constructive ways to try and make the actual lived reality of people's lives in Afghanistan better. And there's a number of different things that I think come up from a human rights perspective, is that we of course think about the sort of traditional human rights issues that we talk about in this paper, but I also think it's worth conceptualizing issues such as the mass starvation that we were sort of seeing going on in Afghanistan right now as a fundamental human rights issue in Afghanistan. We know for a fact that starvation is widespread. 47% of the population is already severely not able to access food. That's only going to sort of increase with time. We're also running into sort of big issues with regards to the harms that are being caused by conflict. So basically what I think we need to think about is how can we try and make the actual situation better in Afghanistan? And I think there's a number of things that sort of are useful. What has already been sort of shown so far is that efforts by Gulf states, for example, to push for women's rights to education and a right to work has had some minimal positive effects, as has internal and external pressure to allow Taliban to open public schools to women and sort of allow for a right for women to attend public universities. Again, nothing about this is meant to valorize the Taliban's behavior and try and dismiss the fact that they, of course, are engaged in a number of very clear sort of human rights abuses and violations, and that they're sort of, it's a very rough regime in a lot of ways. But at the same time, I do think there is a sort of scope for dialogue, and thinking about dialogue and Cedaw as a potential mechanism for dialogue is, I think, a really sort of potentially useful way forward. And as USIP itself, as highlighted by the recent scholarship by Claire Combative and Andrew Marsh, has highlighted there are potentially ways through Islamic jurisprudence itself to actually try and make some positive contributions. And again, I'm not going to say that this is perfect, but we are really sort of left with a core fundamental question that maybe we can talk about more in the discussion, which is when you're faced with really, really difficult legal pluralist situations, what do you do? Do you try and have some incremental progress, or do you sort of say that non-engagement it's just not worth it because certain regimes are so heinous? I'm open to both sides of it, but I do think that there's, given the grave consequences in Afghanistan, more constructive dialogue can hopefully at least make some incremental progress. That's all I've got to say, but thanks again for that.
Thank you so much, and apologies again for the interruption there. We will continue to celebrate International Women's Day and continue to discuss the topics that are pertinent for today, regardless of what other people think. And we again are very grateful for your presentation today, and again are very sorry. And if that's all there is there, we will now pass it on to Ms. Palwasha L.
I kept pushing the unmute button and it wasn't working, so my apologies for not joining sooner. But thank you so much for this opportunity to speak to you all about legal pluralism in Afghanistan. I just wanted to say that I'm not a legal pluralism expert or academic in this field, and I will be sharing my practical experiences, some of the work that I've done looking at the constitutions of Afghanistan, but then I'd like to share more practical experiences on the ground of some of the work that I did when I was actually with the Asia Foundation, where we were working at the local level and supporting women's rights in local communities. So just to start a little bit on legal pluralism and Afghan constitutions, I think it's important to note about some of the legal pluralism that exists. And a particular area of importance is in personal status law. And throughout Afghanistan's constitutional history, from the 1924 Constitution of King Amanullah to the Constitution of the Islamic Republic in 2004, there was this allowance of different kinds of jurisprudence applied to personal status law. So for example, Shias could apply the Jaffrey school of thought to be used in Shia legal affairs, and Sunni to Sunni legal affairs, oftentimes related to women's rights issues. And in some cases, in limited cases, this was applied to Jews, Hindus, and Sikhs as well. So your religious status, you could then choose in terms of on personal status law, some of the things that were applied. What was really interesting in the the talks in 2019 between the Taliban and the Republic was when there was the female Sikh MP, Anarkali Kaur, who was there. The Taliban said, oh yes, we will allow women's rights according to Sharia within Islam. And she said, well, what about my right as a Sikh? I'm not a Muslim, so what does that mean about my rights? And then they added some sort of a clause about, well, if you're from another religion, then we will allow that as well. So it's interesting that that dynamic has existed within Afghanistan. But what I wanted to draw attention to is more on the issue of customary law. And that doesn't have constitutional legitimacy in Afghanistan. So historically, we had Amir Abdurrahman Khan, when he started developing the modern state pre-constitutional period in the late 1800s, he wanted to modernize the state, wanted to have laws that were more modern. He did not want to have religious authority and tribal authority really be the decision makers. But he recognized the importance of the religious and tribal decision-making mechanisms and tried to align them so that they reported to him in his system. Now, there wasn't a formal court system set up beyond that was constitutional until King Amanullah Khan came in, and he established with the first constitution some more rules that sort of laid out the system, and where the king would rule in accordance to Sharia while upholding and promoting the implementation of Sharia laws. But in practice, the laws were developed and passed by the king, the state council, and the council of ministers. And none of these state council or council of ministers included the ulama, the religious judges, the tribal elders. So in response, there was a revolt against King Amanullah. Then King Amanullah held a tribal council where he tried to appease the tribal leaders. Again, he was overthrown because that didn't work. And Nader Khan came to power. And so his approach was more of an accommodationist approach, where he developed his constitution, got it passed with the support of 300 tribal notables in Aloy Jirga. And he did roll back some of the reforms that King Amanullah had set forth, but still the country was on the path to this centralized government and no recognition for customary law in a formal sense. And so there were these tensions that continued to exist between the centralized government and a push for a very modern legal system with unified laws and customary laws being completely separate from that in terms of, for example, Pashtun Wali, the whole Jirga and Shura system at the local level, which were based on oral precedents and did not have any codified written legal system around them. But still, customary law in that sense flourished. And part of it was because of the lack of the reach of the state. So, they were very slow in getting judges educated and then setting up courts. And it required also people to buy into the system. And so when it suited people, they would choose to go to state courts, but when it was in their best interest to use the customary system, they would use the customary system. And really, the government didn't have the reach to do anything about it, very much about it at the local level. So, for example, when it came to women's issues, on the positive side, we see that women, for example, when they were eloping, they registered their cases in court. So we see out of the registered marriages in court, 40% of them were those of elopement that didn't have support of the father there. So we see this use of the court system versus the customary system in the early days. Really, the issue here was that customary decisions that were made at the local level were not recognized in the courts. And so the other piece to that is unfortunate is that oftentimes the judges would see that there was even an issue raised to the court that a woman would bring related to her right to land, right to divorce, a domestic abuse issue. And in fact, instead of trying to adjudicate them within the formal state court system, would refer it back to the communities to decide. And this tradition has continued, unfortunately, and has been a legacy of the Afghan judicial system. Then in the 80s, we had the Soviet occupation of Afghanistan and the whole fighting, the pushback against the Soviet occupation eroded a lot of the state court systems. And again, customary systems took prominence, but here we started to see the role of religion also taking more prominence, because we had this growing Islamic movement and Islamic jihadi movement. And so we saw this, instead of it just being the jirgas and the shuras deciding based on customary laws, we saw more and more prominence of Sharia taking place in the decisions. And then we had in the 90s, the takeover of the Taliban. Now the Taliban, like Jeff mentioned, they had a different sort of a competing system, and their system was an infusion between the customary system and their interpretations of Islamic law according to Hanafi jurisprudence. And so it was sort of this hybrid intermingling of both customary and religious interpretations. Sometimes where the judges were more trained, they would fall more along the lines of Hanafi jurisprudence, whereas in other cases, it would be more along customary lines. But what happened with this infusion when the Taliban took over was also that there was more of a reinforcement between the state and non-state. So you had decisions that were made at the non-state level, which were then reinforced by state courts, sometimes with an official stamp, that then meant that it was upheld by the police and whatnot in terms of whatever decision was being made there. So you had this dynamic happening. There also was, because there was some more in the formal state justice system, you did have the formally trained qazis that were still there. And so again, people could choose to go to those courts specifically versus the more customary or the infused Taliban customary and Hanafi jurisprudence types of courts to demand their rights. And so there are examples of women going to the more formal religious qazis and asking for their land rights, for domestic abuse issues and those sorts of things to be upheld, and that were upheld. Now, in 2004, after the expulsion of the Taliban and the Bonn Agreement, which led to the Constitution, again, the Constitution of the Islamic Republic was written in advocating for a very strong central governance system that pushed out customary law. And there was a really strong repulsion to the Taliban's efforts, or anything that had somehow brought this reinforcing system. And it was seen as very negative. But even in the central governance system, we saw that cases were referred back to the community. And so it was like that, oh, go back to the community for arbitration. And unfortunately, it was overwhelmingly related to women's rights issues. So domestic violence, land disputes, divorce, child custody, those sorts of things would be referred back to the community. The other problems that we were seeing arise because of the conflict, we've been seeing a rise of cases related to Bud and Batal that were decided in the community-based non-state sector system. So issues related to women being exchanged to end revenge cycles as blood money, women being exchanged between families because they didn't have money to pay for the dowry. That sort of thing was happening and was really curbing on women's rights. And so there was a very strong stand by the formal state to say, no, we have to end any kind of non-state justice system. And these customary systems are bad. They don't support women's rights. And so there was a lot of tension there as it related to that. So now we get to the Elimination of Violence Against Women law in 2009 that was passed. The Elimination of Violence Against Women law was very broad sweeping in terms of protecting and upholding women's rights, protecting women from all kinds of abuse, forced marriage, forced prostitution, sexual harassment, and of course, upholding all of their rights to land, to choice in marriage and that sort of thing. But the way it was designed was that this was an interagency effort to uphold the law. So it wasn't just the Ministry of Justice's responsibility with the Ministry of Interior implementing, or the Attorney General's office. It was the Ministry of Women's Affairs, it was the governor, it was the local authorities that all were supposed to work together to implement the Elimination of Violence Against Women law. And so at every province level, there was a commission of the representative from the Ministry of Women's Affairs, the representative from the Attorney General's office, the representative from the Ministry of Justice, the Ministry of Interior, and the governor. And they were supposed to work on eval law cases. Now, unfortunately, not very many came forward. What we saw, post 2009 era was a very high level of access that communities had to the non-state justice system. They didn't have high access to the formal state justice system. It was more to the local community processes that they had access. So, for example, the survey of the Afghan people that the Asia Foundation was doing every year showed a range between 40 and 60%, where women, when they had issues, they would refer them to some sort of a local process, non-state process. And so one of the projects that I worked on when I was in Afghanistan was really looking at ways to protect women's rights at the local level where they didn't necessarily have access and agency to go and take their courses to the formal justice sector. One of the projects I was working on was called Women's Rights in Islam, where we worked on developing booklets with religious scholars in Afghanistan that talked about there were 15 booklets that focused on different rights related to women. And then what we did was we worked with religious scholars at the local level to do training sessions with tribal leaders and religious leaders at the local level who are making the decisions related to women's rights issues. So we call them the local gatekeepers. What happened was, instead of this being just training sessions related to these booklets, the tribal elders and the religious scholars actually brought cases to the sessions to work on resolving. And so it became this process of, okay, so how do we apply what you're talking about within Islamic law and within the laws of the country? How do we apply that now to this specific case? And it became a very interesting dynamic where over the course of a couple of years, it was, instead of being a training, it was actually grounds where people were working through cases, and we could then connect them to the eval commissions at the provincial level. We were trying to have these sessions small, 20 to 30 people. They were ballooning into 60 to 80 people wanting to join each of these sessions in the local districts because there was so much interest, and they wanted to have the knowledge and wanted to know how to resolve some of these very important cases. And we saw, once we started documenting them over the course of the last 3 years of the project, there were over 350 cases that were resolved through this system. Now, from that, we decided that the next was actually to develop this a little bit more formally. Instead of it sort of being ad hoc, where people were bringing their cases to this sort of training session, and then we were linking them up in ad hoc ways to the eval commission, we decided to actually do this more intentionally in Kunduz. And there we actually, it was tribal leaders coming together and talking about their cases, but we made sure that in those conversations, baked into those conversations, were tribal leaders, religious leaders, but then also representatives from the Women's Affairs Commission, the eval law commission, and then monthly the governor's office, the MOJ, the MOI would all meet with them as well. And what ended up happening was, as those decisions were being dealt with jointly, it wasn't just the customary law that was being applied or Islamic law that was being applied. It was sort of this intersection of all the legal systems being applied, and ended up being then having the stamp from the court and being upheld in court. So issues related to women's rights to their land were not just a decision made by the local tribal authorities who had some level of degree of implementing it, but also was then upheld with the court, with a judge supporting that decision, and then the police could actually be called in to support that. Similarly, on divorce issues, on issues of domestic violence, on ending any kinds of engagements that were forced engagements, that sort of thing was happening. And so it was an interesting dynamic where, even though the non-state customary law wasn't officially recognized by the state, we were seeing how this layering of interactions was then supporting the protection of women's rights, where there was the local level being able to help implement the decisions that were being made alongside of the state level that was being able to support those decisions if the local level couldn't. But it came with very, very careful training at that local level, so that the customary and the religious were then were in conversation about making those kinds of decisions and protection for women's rights at the local level. So now we're back to the Taliban being in power, and this system is very much in flux. We're seeing a lot of local decisions being made at that hybrid level again, where you have the customary and the religious infusion. And I think that the state, those who still remain from the Islamic Republic side that are in the state systems are very confused about how to uphold state laws and where exactly the lines are in terms of upholding state laws. I think some sort of a constitutional process will bring clarity to this. But right now we're really at this, at a place where unfortunately there are a lot of intrusions on women's rights, and we are seeing again women being beaten and flogged, women being stoned and killed publicly without due process. And it is a very scary time because of the way the legal systems exist and because there isn't clarity. And also, of course, because the Taliban have not made commitments to uphold and protect women's rights. Like Geoffrey said, there have been some moves on women's education, but there still needs to be a lot more clarity on this issue. We have been hearing that there are some the possibilities of some religious councils coming together to bring clarity to this. But again, there's a lot of unknowns there in terms of whether that will be helpful for the protection of women's rights or not at this point. So thank you for this opportunity to speak again.
Thank you so much to all of our speakers, and apologies again for the Zoom bombing on this International Women's Day. We're looking forward to continuing the discussion in spite of potentially being discouraged to do so. With that being said, we'd like to open it up to questions. So if there are any questions from the audience, feel free to either raise your hand or you can leave them in the Zoom chat, and Juliet or I will read them out as they come up. So please join me first in thanking our speakers. Any questions to get us started? Ordrin, please go ahead.
Thank you so much, first of all, to all three speakers today, and happy International Women's Day to everyone. My question is for all three of the speakers concerning Cedaw, but also advocating for women's rights. I understand currently, specifically in Afghanistan, I understand currently, I do not think there are any governments in the world that recognize the Taliban as the government of Afghanistan as a legitimate government. So do you, and I know Dr. Swenson, you did mention this at the end when you were talking, but do you think that the problem with advocating for Cedaw or advocating for women's rights in Afghanistan would mean potentially advocating for the legitimacy of the Taliban as a government itself? And we know that the Taliban is historically and currently a source of oppression against women. Or do you think that's a defeatist attitude because the alternative is to just not advocate at all and let women continue to suffer? Thank you.
I've said a little bit about this already, and so maybe if one of the other panelists want to weigh in first, that would be great, and then I can sort of circle back around. I do have some more thoughts, but I want to make sure everybody gets a chance to speak.
Sure, I can start. I think, this is really the big question here is how do we work to support the Afghan people without recognizing the Taliban and giving them legitimacy? And I think a lot of governments are around the world have been trying to do this in different ways. Talking recently to the UN, Deborah Lyons, who's been leading the UNAMA in Afghanistan, she was saying, on the one hand, we have to interact with them as the de facto regime without recognizing them, but at the same time putting pressure on them to make changes happen related to women's rights, and making sure that the flow of humanitarian aid can continue to come into Afghanistan. So it's a very difficult fine line to walk there. But in terms of advocating for law, I think it's even more nuanced because of law being part of a state system, and a constitution, and constitutional processes being part of that as well. And while there has been advocacy for having having some sort of an inclusive process towards governance in Afghanistan, and some sort of a constitutional process to start defining the laws, calling for that kind of a process doesn't necessarily mean that they're advocating for the recognition of the state. So I think that can happen, and we've heard that happen by states so far already, but it does run the risk of becoming very close to legitimizing, especially if the Taliban do follow through on the recommendations, and then there's something that comes in return. And so we're sort of stuck in this cycle of do we say, okay, it's okay to recognize them as de facto regime, but not officially, so that we can get things moving and support the Afghan people? Or do we really want the collapse of the current Afghan state? And what would that do for the Afghan people? Is that going to be better for the Afghan people in that circumstance? And so that's a lot of the conversations that we're hearing in this space.
I think I have probably an easier time answering the question, because I just found, I was just Googling the Cedaw committee, and that's the statement that the committee came out with in August on calling on the Taliban to protect women's rights. And I'm sure the Taliban ran to the Cedaw committee website to read it, but it does talk at the end of that statement about how they hope that how Afghanistan will continue to implement the Cedaw committee's recommendations from February 2020, that they look forward to engaging with Afghanistan on the third periodic report. Because at the international level, Afghanistan is still a signatory and ratified Cedaw. They haven't withdrawn their commitment to the treaty, so they can still engage with it. I can't imagine the Taliban will be on time with getting that third periodic report in, so it might be a bit moot, but they do have mechanisms, at least, to release statements that don't really require engaging with the Afghanistan government or legitimizing, where they can just say, we are worried about what's happening on the ground there, and we call on the international community to protect women's rights at the highest level. But from what that statement says, it sounds like they will, if they submit a report, that they would engage with it. I see there's a question for me in the chat, so I'll have a read it while Jeff is talking and think of my answer.
I can't unmute. Thank you. Basically, I agree with these comments. And one of the couple things I just want to add and maybe push the conversation a little bit more is I think that recognition can be a policy tool. I think it's an important source of leverage because it is something that the Taliban government wants. When we're thinking about areas to sort of make sure that human rights abuses are mitigated and ideally redressed, that's a potential tool. But I really do also think we need to be having some caution here, because one of the sort of trends that I've noticed I find particularly disturbing is human rights concerns oftentimes are used as policymakers' excuses for not dealing with the ever-growing humanitarian crisis in Afghanistan. And I really do think that the Taliban is the government. They won the war, and this is the reality. And so we have to think about, how do we actually make this situation better for the people of Afghanistan and mitigate the abuses and try and build something better. And I just really do believe that if you're using the existence of the Taliban government as an excuse for perpetuating a humanitarian disaster, which, by the way, overwhelmingly disproportionately impacts women, I think that raises some real profound issues. So I think we need to think about, how do we use the process of recognition? How do we use the leverage there in order to help make sure that this ongoing situation does not become an ever graver thing? Because again, people are dying because of the humanitarian crisis in Afghanistan, and that's a reality. And so we need to think about what we're going to do about it.
Amazing. Thank you so much for these answers. Sophie, if you want to go ahead, we'll go with your question, and there's a few in the chat, so we'll return to the chat.
Thank you. Sorry about the background noise. I hope you can still hear me clearly. So thank you so much for all of your presentations. And as throughout this session, I was thinking about this tension between sort of big centralized instruments and localized solution, and the need for a dialogue between the two. And to bring us a bit, perhaps unfortunately, away from Afghanistan, I was thinking as well about the withdrawal of Turkey from the Istanbul Convention last year. And was it 2 years ago? I don't know, sorry. I forget about the pandemic years, but and so I know the Istanbul Convention is based on Cedaw and was sort of like trying to codify Cedaw into a more binding law. And I was wondering, how can Cedaw, would you think that what led to the withdrawal of Turkey and then the subsequent sort of threat of Poland and Hungary also saying that they wanted to potentially withdraw from the Istanbul Convention, do you think that Cedaw is best to be kept as a convention and not to become a legally binding instrument in order to deal better with that tension between localized instruments and sort of centralized big instruments? I hope that's clear. But thank you.
Yeah, it raises a really interesting and challenging question. Is increasingly the threat of withdrawal from international or regional agreements is very real, and it's often used as a stick or used to intimidate or to kind of water down. We can see this in relation to the country that I live in right now, the UK, and the European Convention, where European Court might act a bit trepidatious around the UK because they're so afraid of pushing them into withdrawal that and so we can see something similar happening with women's rights, where prominent members are withdrawing from these treaties. And so the question, of course, is what to do. And I think personally that kind of watering down or appeasing or trying to make things more palpable is actually just feeding into gender backlash and is not really going to, it's not going to convince the party that wants to withdraw that, okay, we'll stay, because I think often women's rights are a smokescreen for a larger conversation around globalization and a sort of a re-entrenchment of nationalism. And that these treaties are kind of cannon fodder for those larger movements. And women, we can see this with the gender ideology that's springing up in different parts of the world about more conservative viewpoints on women and how that's being legalized. And it's all part of a larger anti-backlash against globalization, anti-backlash against women, pardon me. And I think when it comes to Cedaw, it is in a kind of strong position because it doesn't say anything that's binding. I mean, you can ignore it till your heart's content, and many states do for many years. So I think the fact that it's not directly enforceable, it is purely recommendations. My own perspective is that it means that it should be taking a much harder line and should be taking a very firm line, because it's not going to affect domestically directly what's happening. It will, if the CEDAW committee says something strong about gender-based violence or legal pluralism or trans women's rights, that doesn't have any immediate domestic effect. It has to be translated through political grassroots activism or legal activism. So because CEDAW is kind of a standard bearer, setting standards, and those things have to get picked up by domestic actors, my own view is that it has to then be quite strong in setting really transformative, substantive equality standards that can be picked up. And it shouldn't be tepid or afraid or watered down or trying to appease a gender ideology or to mitigate gender backlash. There's an interesting report, if you're interested in these issues, from the Working Group on Discrimination Against Women. It's a UN working group, kind of like a special mandate holder. And they wrote a report in 2018 about combating gender backlash. That's quite good.
Thank you so much. An interesting, just a comment from Professor Hoodfar in the chat that is really interesting as well for all of those who have the chance to read it in terms of researching Cedaw and Islamic law and customary law. The next question, oh yeah, Megan, did you wanna, I saw a hand.
Oh, I can actually answer the question about trans rights.
Yes,
women.
exactly. That was
Okay.
the one that I was gonna ask you to
Okay.
please answer Kassandra's question.
Yeah, so that one's, I actually was involved in a workshop this summer about bringing together experts and some Cedaw committee members and the UN Special Rapporteur on Sexual Orientation and Gender Identity, thinking about Cedaw and trans women. And again, I don't know how much this has made it over in the Canadian press, but it's definitely in my UK feminist Twitter is rife with what they're called the turf wars. It's trans exclusionary radical feminists who do not see trans women as women and only see cis women as women. And it's a very heated debate within feminism in the UK, actually a couple months ago. And the Cedaw committee in the workshop that I co-hosted with a couple others, and there's a report, if you're interested, I can send it to you. It's a bit embargoed right now, but it's going to be released, I think, within the next couple months. Calling the Cedaw committee to be more, to my earlier thing about being more transformative and radical, is to be more stronger voice for trans women and to think about the role of trans women within Cedaw. And currently the committee is quite, it's clearly dodging a bullet or trying to avoid saying anything too radical. In part, that's because the Cedaw committee does make decisions by consensus, and it is an international body of 23 members who have very different backgrounds and may have very different viewpoints and opinions about trans women. And it's within the UN system itself, which is, some people might argue, conservative in a kind of small c sense of the word. And right now the committee kind of tack on mentions of trans women or tack on mentions of non-binary, but it hasn't yet really fully addressed the equality issues around trans women. It's never really firmly said that trans women are women within the definition of women within Cedaw. That's a big gaping hole. And I think part of the report in the workshop was kind of trying to advocate and bring and have committee members at the workshop to sort of push them to be thinking about general recommendation, general comment that puts more attention on women's sexual orientation, gender identity, because I think it is a real gap. And I can't really speak to those issues in the sense of post-conflict, but I know that from just my reading of the concluding observations over the years, very limited addressing of gender identity, sexual orientation, equality in relation to post-conflict. It almost never is mentioned. And if it is, it would just be in passing. But if I had to take a guess, it's not going to be in the concluding observation for Afghanistan. It'll be kind of bypassed.
We had a question come in directly for Palwasha. Maybe we can take that one and then move to Ordrin.
Sure, thank you. So the question is about cooperation across local traditional governance models and entrenched state legal systems. What lessons can we draw from these systems of legal pluralism to advance gender justice? I think here, what's really, there's a number of things that we learned from that project. One is that it is possible to have local buy-in among men and have male allies to protect and uphold women's rights. And it is possible to work within legal frameworks, local legal frameworks, non-state legal frameworks, to develop those kinds of protection mechanisms within the community. And that those kinds of protection mechanisms are very sustainable. It remains for a long time, no matter what kind of regime changes happen, you have those people who are there at the local level making those decisions. And if it is within a sustainable system, so as government systems change, you have the Republic and I have the Emirate, and their systems and approaches to the formal state sector is different. What is infused at the local level that is sort of transcends that. So in a sense where, we talked about the protection of women's rights, looking a little bit at some of the customs within Afghanistan, but then also looking at Islamic and Hanafi jurisprudence, Islamic law and Geoffrey jurisprudence, and giving the reasons why it is in their moral imperative to uphold and protect the women's rights at the local level, so that it continues no matter what else is happening at the higher levels. But in terms of giving those messages, as important as the message is the messenger. So it's really important to get the right kind of messenger to give those messages that have a legitimacy at the local level that can convince and change actually the mindset of people at the local level. So we had in different areas, it was, we had a little bit of a different reaction depending on who the person was giving the kinds of trainings. And so we had to adapt to make sure that the people who were giving the trainings were people who had the legitimacy and authority to give those kinds of trainings at the local level. And what for me was surprising when we started this project was the way that the booklets were framed were very much looking at what is their role as men in society, as the leaders in society, male leaders in society, in protecting women's rights. So it was very much couched in male-centric language as their role and responsibility in this. And so we had to translate that when we were working with women and doing these trainings with women. And I was very skeptical when we started this process, but it's really something that stuck in terms of targeting it very specifically to their roles and their responsibilities in upholding this. Now, I cannot speak currently to what's going to happen, but we have seen sustainability for a while with many of the ulama groups that we had originally worked with and the tribal leaders locally, even in places like Kunduz after they were taken over by the Taliban. But again, right now the system is very much in flux, and there's a lot of things that happen by the force of the gun and bullets, and it's really unfortunate circumstances right now. But I have to say, overall, taking that kind of local level approach is sustainable.
Thank you so much. Sorry, Juliet, go ahead. That's just such a nuanced, and it was just such a fantastic answer. It was really nice to hear your thoughts on that.
I was going to say the same thing. Okay, and then I think we're kind of coming to a close, but Audrey, if you want to ask your question, I think that might be one of our last ones.
Thank you. My question is just a follow-up to Dr. Campbell regarding her response with including trans and non-binary women in Cedaw. I was just wondering though, because I know like with Cedaw and also with like the conventions on the rights of the child, it's really difficult to get all these countries to agree and ratify. And from my understanding, it's the UN's goal is to get as many countries involved as possible. So wouldn't it be more realistic for it to be a domestic activism where in this specific countries, people are advocating for inclusion of trans women's rights in the domestic policy? Because I just know, like, even like with the Convention of the Rights of the Child, there was so much difficulty on getting countries to come together and agree what is the age of a child. So I feel like with trans women's rights and the recognition, it would be even more difficult. So I was just wondering, do you think maybe domestic is better than at the international stage?
So I don't think either one is better than the other. I think they kind of work in synergy. So I think I agree that trying to get a new treaty on gender identity and sexual orientation would be in this political moment incredibly difficult, and would be they're slow to begin with, even if there is political momentum. But in this climate, it seems there's almost active political momentum against sexual orientation, gender equality. So I wouldn't say advocating for a new treaty would be probably all that successful, which is then why I think it's so important to use existing treaties that already have broad ratification, like the rights of the child, or like Cedaw, to think about how to use the treaties that exist to advocate for trans and sexual orientation equality. And then I think this is where there can be a positive relationship between international and domestic, where the international can set a standard. It can say trans rights are human rights, or trans women are included within the definition of women, or I think for children's rights, that the sex education around trans and gender identity and sexual orientation is so important, and they can be really advocating the importance of having access to high quality sex education that's inclusive. And then when they set those standards, then it's up for the domestic grassroots activism to use them in their activism, their litigation, their political strategies. And it can just be another tool in the sort of activist toolbox to say, it's not just us, this small group saying this, but this is also kind of what this larger kind of authoritative international body is saying. So I think that could be kind of a beneficial relationship between the two, and that the domestic bodies can bring their complaints, their concerns to these international ones. And then the international body can say, this is what we think, and this is why we think trans rights are so important and how they need to be protected and upheld. And there is some evidence of a fruitful dialogue back and forth. It's not always as consistent as one would like, but it does exist. And I think because the international bodies are have that global reach and that authoritativeness, it's important that they speak up loudly on these issues.
There's a comment in the chat that Professor Hudfar would like to make a couple comments, so maybe we'll pass it over.
So thank you very much for this very interesting panel. It made my day because it didn't start well, but I had just a couple of quick comments. One is about humanitarian assistance, and we keep focusing on quite rightly on Afghanistan now, but we also have to see the UN. Well, the different states have used UN to actually stop humanitarian or any kind of thing to put on countries. Like, we shouldn't forget, I know you're all young, but some of us are older, and remember what happened in Iraq. They had the hardest really thing that they put on them, and so they couldn't even import aspirin. A lot of people died as a result, and there was very little really UN started to work. But then, of course, after 9/11, everything was forgotten. And I think it's a good time for some of us who are interested in this to look at to look at these things in a broader perspective and find ways, because people in a country should not be used as a weapon for international community, different state fighting with each other when people are dying. So that I just wanted to put on the table. The other comment I wanted to make is often, unfortunately, in the literature, I always present Islamic law or Sharia law as one block. Firstly, it's very different as it's used very differently in different countries. And the other thing is, often when we talk about policies, as earlier on someone mentioned that we see the culture and laws as differently and as or not incorporated. To carry out the kind of research, like in this case, in the context of Middle East or the Muslim majority, to look at how it's actually exampled, how it can be twinned with the international community and the changes, it will actually help the discussion. So also, we are not completely all the time accused of importing Western ideas, especially on Cedaw. I often have to say the only Western country that was on the committee was Austria, which is not the most powerful state in the West. They were all, otherwise we're all people, a state from developing country, 8 of which were Muslim out of 20, is it 21 or 23? I don't remember the number, but quite a substantial number were Muslim. And yet in every Islamic country, when you discuss it, they all say, these are Western. And if people don't know the history, they accept that. But they also, the other thing is, very few of us at the international level, we just discuss about where they actually converge, where they differences, how can we solve the differences, how can we bring human rights issues closer to some of the Islamic ideas. And since they are also, the reason why a religion lasts for over 1,000 years is because it's able to evolve and change and respond to the reality on the ground. If we don't do this, because for political reason, it's always easier to justify everything that is wrong in this region is because of Islam, then we basically shoot ourselves in the foot. We can't then go ahead. So I think it is, especially I encourage young scholars to look into these laws, or whether it's Cedaws, whether the other human rights issues, they come together, and where are the convergences, and how can we resolve those, to what extent we can. I'm not saying necessarily all can be resolved, but I think, unfortunately, I think for political reasons, these were not given the importance that they should have been given throughout, at least since the Second World War, if not earlier. Thank you.
Thank you so much for those comments. So I believe we have reached the end of our time. I personally just want to say thank you to all our panelists, and on behalf of the team at Inter Gentes and the Center for Human Rights and Legal Pluralism, just thank you for participating in this really interesting discussion. If you want to continue the
yeah, I just wanted to reiterate a big thank you from our part. If I know we're over time now, but that was a really rich contribution. So if Jeff, Megan, or Palwasha, you'd like to kind of respond to that, please feel free to do so before we close. But I'll just close on our part by saying we wanted to thank the 3 of you sincerely for spending your time with us here today. It's been such a pleasure orchestrating these different voices and kind of different disciplines and different kind of subject area approaches that all intersect. I think it's really true to the spirit of the journal, which is essentially what it intends to do, marrying legal pluralism with international law. And so thank you to the three of you very much. Once again, thank you to Sharon for her support in organizing the event and the Center for Human Rights and Legal Pluralism broadly. And also thank you so much to you all, the audience. We hope that you learned something interesting and useful today, and it was a good way for you to kind of enrich your understanding of this area on International Women's Day. So if you'd like to respond, give us maybe a closing, if you'd like to say anything, please feel free, otherwise we will close.
I'll say something really quickly, just because there was a question in the chat I wanted to briefly mention that's relevant to the question. First of all, thanks again. This was a really, really interesting conversation. I learned a lot, and it was a really, really enriching discussion. I just wanted to say something briefly about interdisciplinary research, because I think there is so much to be gained from it. And I think it also really speaks to the comments that were just raised, where we have to sort of understand politics. Politics can be something which suppresses women's rights, but can also really be a positive force. And I want to end on a sort of more positive note, not from Afghanistan, but from the other country that I focus on, which is Timor-Leste. And Timor-Leste has made a lot of gains in human rights, especially women's rights. It's not perfect. There's plenty of things the Cedaw committee will be able to identify as areas for future improvement. However, I did want to note that one of the biggest changes was actually a political change, and something that was perhaps unexpectedly. So think about what might be useful ways. And basically what Timor did was they changed how customary leaders were chosen in a way that was broadly acceptable and actually had a really positive impact, which was, instead of having traditional leaders be pure ancestry, they did it via open democratic elections that were nonpartisan. And so, of course, you would still have maybe ancestral leaders having success, but for the first time, there was real meaningful accountability. And you would see, not everywhere, but in a lot of places where women were mobilized, and if there was a particularly unpleasant Suko chief, that person might be voted out. Women themselves became Suko chiefs, and not as many places as they should be, but certainly in more places than they were before. So thinking about different mechanisms to actually use politics as a positive for advancing women's rights is certainly possible, even in a challenging post-conflict setting. So thanks again for a great talk.
Yeah, thank you. I also wanted to just end in saying that, Homajan, I really appreciate your reflection there, and recognizing that those who also developed the Cedaw Muslim states were among them. And I think that's something that we forget also with the Universal Declaration of Human Rights, the role of religion in that. It has become this dividing factor, as in this is a secular thing and the religious are on the other side, without recognizing the history behind the role of religion in both of those documents. And I think it's a really important point that you raised, that we do need to have more religious literacy on these issues to be able to promote them and show how they're actually interrelated and connected and where the commonalities are. So thank you for raising that.
I'll just briefly say thank you as well. It's been a really wonderful way to celebrate International Women's Day. I didn't have any real plans for it, and this is definitely a highlight of the day. It's been wonderful to talk to everybody and learn so much and get that rich interdisciplinary perspective. So thank you.